EXP for the South Texas, San Antonio region. So I've been here, it'll be 3 years this January 3rd. So welcome. So going forward, our 1-4 contract should have the date 11/04/2024 in the upper right-hand corner. And we'll just run through it and show you what changes they have made. First one is going to be under leases. About all they've done is add geothermal to it, and it's just another category of natural resource leases that are potentially on properties in Texas. Again, these are pretty much all the same. And as I said, if anybody has any agents that have any questions, about the entirety of this contract, have them attend the 1-4 class on Thursday at 1:30. So our first big change, which I love because I always hated having to send clients out to get notarized because they wouldn't do it in a timely manner. They felt like you were asking them to go perform brain surgery, to go by UPS or their bank to get something notarized, or God forbid, have to pay $5 to get it notarized. But now we have the option of using either the T47 affidavit or the T47 declaration. So I'm sure most of us will be using the declaration because the declaration does not require the sellers to have that notarized. And I'll just clarify, the affidavit, the T47 is a declaration and an affidavit where the sellers of the property, if they're providing the buyers with a existing survey where they are either affirming or declaring that nothing has changed to the property and the property exists exactly as it is shown on the survey that they are putting forward. So here again, it's the same rules that, no 3 days, same rules as being able to terminate and cancel. One thing you always need to remember with the T47 and the survey have to be delivered within the time frame that's indicated in paragraph C1. So if it says within 5 days, within that 5 days, you need not only to have the survey to the clients or to the buyers, but you also need to have the T47. Now we have the choice of the two. So if the T47 isn't delivered, that opens up the buyer to some of the other remedies. So the other big change here is on 2. And if the buyer is going to obtain a survey, which you can see may obtain a new survey at the buyer's expense, but they've added, and so they've gotten rid of one of the buyer outs. So if the buyer fails to obtain the survey, the buyer may not terminate the contract under paragraph 2B of the third-party financing addendum because the survey was not obtained. Hang on, let me set some more people in. So 2 big changes right off the bat. So what that means, if the buyer is responsible for obtaining their own survey, they fail to get the survey done in a timely manner, and they don't get it at all to the lender, and then the lender will invoke, will say, this property does not meet our underwriting criteria because we have not received an updated survey. If it's upon the buyer to provide their lender the survey under these terms, if they fail to do so, they do not have that automatic out anymore, which is a big thing. So, 2B on the third-party financing addendum was always like the given, we can get out. It doesn't meet lender's criteria, so you can get out. So now the buyer, it's very important, the buyer must get it there in time. If failure to do so will make it so they cannot terminate the contract under 2B of the third-party financing addendum. So for the ones that have just joined a little bit late, the first thing that's being changed is now we can use the T47 affidavit and the T47 declaration, and the declaration does not need to be notarized. Any questions?
Alan, on the declaration, is that something we're able to use? So say they put a shed, and like previously on the T47, we had that line that we could write on there, added shed, and then they could hand draw it on the survey. And a lot of times, you know, the lender and or the title company would accept that. Is that the same on the declaration, or is it just if absolutely nothing has changed?
Pretty much, I would say yes, you're still going to be able to do it because the main yes, there is the accept on the declaration.
Thank you.
So, and a lot of that, you know, most of that does come down to what title and your lender is going to accept. But yeah, there is the 2 lines that you can put in there on the declaration where it says accept. So typically if somebody puts on like the garden shed or runs a sidewalk, you know, it's not in, you know, it's certainly not encroaching on any of the property lines, or it's a permanent structure. For the most part, the title company and lenders are not going to have any issues with that. You know, it's certainly when something affects property line setbacks, adding permanent structures, adding a pool, you know, additions, you know, adding covered you know, not really covering the patio, because the patio, a lot of times they'll just say, well, the patio was already there. All we did is added the cover on it. So that's really not affecting the survey, but that will affect other things, as we know, as far as permitting and stuff down the line. So again, making sure that we're going forward is 11/04/2024. So here's some new additions. Paragraph 11, and this is under 6. You know, number 11 under 6. Certificate of mold remediation. If the property has been remediated for mold, the seller must provide to the buyer each certificate of mold damage remediation issued under 1958.154. Feel free to go open that up and read it. Occupations code during the 5 years preceding the sale. So it goes back 5 years. So if anything has happened as far as mold related remediation and repairs within the past 5 years, the seller must provide those certificates of remediation to the buyer. Any questions on that? So that's going to be a big change, because we're going to need to make sure we have those conversations with our sellers. If they've had any mold remediation, that we need to make sure we're going back 5 years. So number 12 is now, which was the old 11. Now they've added, you know, required notices. The following notice has been given or are attached to this contract. For example, utility, water, drainage, public improvement districts. So they've taken out the abbreviations. I know a lot of agents were confused on exactly what they meant. So they got rid of the abbreviations and actually wrote out in words what they are. And then they've also added at the bottom, the seller's failure to provide applicable statutory notice may provide the buyer with remedies or rights to terminate the contract. So the big word in that is may provide. So we don't want to, as real estate practitioners, make definitive statements that if somebody fails to do something, then this will be terminated. This will be in breach. You know, we always, like it states here, may. So always make sure that it's we're not out there definitively defining that someone has breached the contract or is in violation of the contract or has failed to follow the provisions of the contract. So we want to stay away from that. Why? I've helped agents that have made statements like that. TREC does not like to, doesn't look kindly on that. And for the most part, it's about a $3,000 mistake if TREC decides that you were stating something legal that was not true, or performing inserting a legal opinion on whether a contract is valid, invalid, and breached. So be careful. Always predicate any statements with "it may be" or "it could be found." That's up to a court of law. That's up to attorneys to interpret. Stay within our lanes of being a real estate agent, and we'll be all safe. Anybody got a question on that one? Pretty simple on that, not much different. So where are we coming down? So here's the big one. The number 12, settlement and other expenses. So the blue is what's changed. So the seller may pay the following expenses. The seller shall pay the following expenses. So they're very definitive on what they're doing. Releases of existing liens, including prepayment penalties, recording fees, release of seller's loan liabilities, tax statements, certificates, pre-preparations of deeds, 1/2 of the escrow fee, brokerage fees that the seller has agreed to pay. So they've added that one. So now when you're, unless you've amended your listing agreement, they are bound with what's been added to the contract, that they're bound to pay what they have agreed to in our listing agreements, and other expenses payable by the seller under this contract. Now, this is where this 12, does anybody have any questions on that one? It's a little bit clarifying the language of what was already existing. I like that they added the broker fees that the seller has agreed to pay. So that's clear and concise. And so the big change here is 12A 1B. And that is the following amount to be applied to brokerage fees that buyer has agreed to pay. So it can be flat fee, or it can be a percentage of the sales price. Check one box only. So we can't be putting in there like a bonus and then 3%, a bonus or 4%. So it's that is going to be handled a little bit differently. And I think we would have to, we'll have to look at those on a case-by-case basis. But typically this is going to be, what the buyer has agreed to pay, the buyer's agent. This is where it gets difficult. And I've talked with TXR's legal hotline, and they even agree that this is going to be a little bit unusual. But 12A 1B replaces or is in lieu of what was on D2B on the 2406. So as EXP agents, since we're not going to be participating with broker-to-broker compensation, we will be putting our request for buyer agent compensation on 12A 1B. So if it's 3%, we're going to be putting 3% in there. But this is where it's going to be confusing. If the listing broker is following and utilizing cooperation broker-to-broker compensation, there's going to be nothing put there. And you're going to have to use the 2402 compensation agreement between brokers. So when we are, as EXP agents, when we are first sending over and putting our offer on the 1 to 4 for our buyers, what we're going to be doing is utilizing 12A 1 B and putting what's your request for buyer agent compensation there. Any questions? Did you all get that the first time?
I
I
didn't.
have a question.
Yeah, I have a question too.
Can
but-
you repeat that?
Yes. So let's stick with what, let's start with what, how EXP wants us as agents for EXP to submit offers. So going back until when we had the 24/6, so what EXP leadership requested that we do, we submit our 1-4 along with the TXR 2406, putting our request as buyer agents, our request for compensation on D2B, Delta to Bravo. But let's just use 3%. So we put our 3% there. And then we submit the 1-4 along with the 2406. So now with this change and with TREC adding this B under 12A, that is why they that's where they made the decision to no longer use the 2406, because if you think about 12A1B, that is the equivalence of the 2406 D2B. So when we as real EXP agents we're submitting an offer to our broker going forward with the new 1-4, we're going to be putting our request for buyer agent compensation on that line, that B.
Hey, Alan.
Okay?
Hey, Alan, yeah, so and that amount there, that's what we're asking the seller to pay on our buyer's behalf or for our buyer. We're not disclosing the amount the buyers agreed to pay on the buyer's rep there, right?
Correct.
Okay.
So just think of that, utilizing that line like we were using the 2406 D2B.
What if they're offering a bonus? I think I missed that part about if they had a bonus or something like that.
The bonus, see, we're still working on how you're exactly going to use the bonus on this. And I think what we're going to be able to do is I hate to say it, but it's going to have to be drafted almost in special provisions. Because without that, or what you can do, probably the best, I take that back. I would say probably the best way to do that, if they're offering a bonus, is figuring out a percentage amount, or utilizing, instead of using the percentage, figure out what the percentage of the sales price is going to be, plus the bonus, and putting that in on B as a flat fee.
Could we do it, Alan, as an addendum to the buyer tenant rep?
Yes, you can. Well, you're going to have to. And that's a great question, because if you're going to be accepting any bonuses or anything above and beyond what you've already agreed to, as far as your compensation from the buyer, if that changes either up or down, you're going to need to amend that buyer agent or that buyer broker agreement with your buyer to be able to collect it.
Isn't bonuses already included on the long form buyer rep?
No,
But
it mentions it, but you'll have to amend it.
How are we supposed to mark this if it's an intermediary situation? Is it the same?
Yes.
Okay.
So now, and that's what I brought up when I talked with the lawyers at Texas Realtors, is if it's intermediary, because now without the 2406, which they realized was lacking because it did not address intermediary, and they modified it and amended it to have paragraph E. Now we don't have paragraph E. So what if it's an intermediary? Then that compensation for the buy side intermediary agent would be put in under B. So if it is, if they're getting if they've agreed with the buyer to get paid 3%, then that would go in B.
One
As
more
a percentage
question.
of the sales price. Yes.
On where you were talking about in regards to bonuses, either figuring out the percentage or doing the flat rate. If we did a flat rate and say the appraisal comes back and that then is changed on an amendment through negotiation, potentially lowering the price, if it's a flat fee instead of a percentage to include the bonus, does that have to be amended too?
Yes, and we'll bring up the amendment because the amendment to the contract that also has changes, and what they've done is added the ability to change what you wrote in 12A1B on the amendment.
Thank you.
I got another question on there, Alan, as well.
Mhm.
So we've got to amend the buyer rep agreement if that gets adjusted up or down. So if we agree to like 3% with our buyer on the buyer rep agreement and the seller agrees to pay 3%, does that mean we have to go back and amend the buyer rep agreement to 0?
No, never, ever, ever take your buyer rep agreements to 0, because that's exactly what you'll get paid as a buyer agent.
Okay, so I'm not following the idea of amending it up or down.
So anytime you agree to a different compensation rate or percentage that you initially started with your buyer, whether let's say you start with 3%, and let's say you go to the builder and the builder is saying, okay, we will pay you, a 4%. So you need to amend that up. And usually what I always tell agents to use, instead of amending, keep that a buyer rep agreement kind of as your base, as your baseline buyer rep agreement, because NAR has stated that any broker can have as many buyer rep agreements with any one buyer at any given time. So you have your base agreement with your buyers, let's say at 3%. You go to Pulte and they're offering a 4%. That's the perfect time to pull out EXP single showing and write it up according to what exactly what Perry is offering for that neighborhood, to include an increase in percentage. So you can have that one single showing buyer rep agreement that addresses what the builders are doing, but then you're not having to amend your original one with your buyer still stays at 3%. So you're not having to amend it up and down, up and down. You're just as different circumstances of compensation from different sellers arise, you can just use the single showing and adjust for that showing and that buyer rep agreement for that particular property.
So we should almost use that single showing in lieu of the amendment?
Yes, in lieu of the amendment.
Okay, and then we don't, if we're adjusting down, let's say just with another seller that says, I'll pay you 2%, but not 3%, we're not still expecting 3% from our buyer. We just use that single showing to say we're getting 2% from the seller.
Yes, the single showing can be used as a amendment.
Got it.
So, and it's got to be important because what they've added also. So, but here again, with the directive from leadership, and leadership has come out directly, and this is from Leo also, as stated it multiple times, EXP is not going to get in the way of its agents being able to make money or get in the way of their buyers being able to purchase a home. And this goes in line with our decision to not participate in broker-to-broker compensation. So if the listing broker insists that we participate in broker-to-broker compensation, we can amend that 12A1B to 0. We can sign a broker-to-broker compensation agreement with the listing broker and move ahead. So if we're being required to, we can step back from our company policy of not doing cooperative broker-to-broker compensation or participating in it. If that's what it takes for you to close this deal, for your buyer to get their property, for you to get paid.
What would we have to show compliance in Skyslope that we had tried to get them?
And what you're going to want to show is if you submit, you submit your original, you show the submittal of your 1 to 4, your original that shows that you did put it down there and it changed. And then you can show how it changed, whether it's by parties of the contractors and contract initials, or that you've received seller's invitation to buyer to submit a new offer. And part of that request to submit a new offer is to take any of that percentage out of 12A1B and put it and utilize the 2402 instead. A lot of it, we're going to need to rely on the agent's word for it, because a lot of you, I know I would be doing it, would probably have conversations with the listing agent ahead of time, and you'll be talking what you're going to be doing as far as potential offers, and they'll probably be saying, well, what you're going to need is submit your offer and submit your offer with a 2402. So I do not want to put our clients or yourselves into needless paperwork back and forth. So in those circumstances, if you already know ahead of time, they're going to require and insist that we submit our offer with the 2402, but we're going to have to go ahead and do that. And just in SkySlope on the checklist page, that's a great place to make notation. And if you have those conversations in an email, you can also upload that conversation where the listing agent or listing broker insisted that we use the 2402. So any documentation that you can keep, and either text or an email that they're insisting that follow their instructions as far as how to submit an offer and how to get paid.
Alan, and on the reverse, if we are the listing agent, we receive an offer, we're asking them to submit it with the 12A1B.
That is correct. Because we, on the sell side, that's very important, because we will not get involved in cooperation, broker to broker compensation. So just like we were instructing y'all with your listings, when you accept them, when you accept or receive an offer from a buyer's agent, as with the 2406, they were putting their request for compensation on D2B. And always phrase it request for compensation, because we don't want to do anything where someone can say that we flat out said that they were going to receive 3%. So what I always try to have the agents do when they're phrasing that is phrase it as and include your request for compensation on, now it's going to be 12A1B. It's almost like you got to develop a rhyme to keep going with this. But so I always try to have the agents state it as the buyer's agent's request for compensation, because your seller can say, no, let's change 12A1B to 2.5%. And then you can counter back that way. So we don't want to lead anybody to think that those commissions are not always negotiable until all signatures are on the contract. Any other question on that?
Alan, is this in the Farm and Ranch contract? Any update to that?
I will do. There's Farm and Ranch has been updated, and there are certain things that have changed, but that's going to be another thing to go over Farm and Ranch.
Okay, thank you.
So if the listing broker is insisting that we do broker to broker compensation, that's how they have their listing agreements set up with their seller. That's when we'll get to it at the end of this, on page 10, that paragraph, if they've changed the paragraph on page 10. And then if we are entering into cooperating broker to broker compensation, they would also put that amount on that paragraph on page 10. So paragraph 12A1C. This is for any seller concessions. So if your seller is saying, I will contribute $5,000 in lieu of, whatever to be applied towards, the buyer's closing costs. That's where that's going to go. But you can use B and C together, or you can use C. So C, you can bypass B and not put, not have anything put in there. And then you can have C. So the seller's amount, what the seller's going to contribute is going to be to the overall closing costs of the buyer, which could and might include their buyer agent's compensation. So B and C can be used together and individually.
I know you're not specifying a preference in that, but would that open us up to, like, say, the concessions, like part of our commission would go towards concession if needed to, or would you prefer to see that separate?
Well, that's going to be up to your buyer and your buyer and your seller. So, if the buyer is just going to say, look, I will, I'm not going to specify what I'm paying the buyer's agent. I'm going to leave that up to the buyer. And I will contribute $15,000, $20,000 to the buyer's closing costs, because the buyer is responsible to pay the buyer agent according to the buyer rep agreement. So it can be used that way. Would I be doing it that way? Personally, I think that's going to be, it's an option. I think it's some ways that it is a negotiating tool. It can be used in many different ways, but I think for clarity of the agreement, I would be putting the buyer agent's compensation separately on B, and then leaving the seller contributions as something completely separate. But it's an option, and that's one thing that the attorneys said, that yes, you don't have to have anything in there. You don't have to have the, if the seller wishes to do so, they can put everything in on C and leave it up to the buyer on how that will be applied to their closing costs. And I know this is going to take a little while, so that's why we're back up to 13 brokers in Texas now. So anything that comes up, just reach out to us on that. But for now, the main point is for EXP agents when they're submitting their offer, all things being the same, we'll submit the offer with 12A1B indicating as a buyer's agent, our request for compensation on B. We have C there to indicate what we would like or what the seller would like to contribute to buyer's closing costs. And so that's also an option. Okay, yes, who's got a question?
So I have a question on B. If you look at that verbatim, couldn't that scare a buyer and say they could think to themselves, I have to pay you 3% in addition to my down payment?
No, because it's the way it reads, the following amount to be applied to the seller's fees that the buyer has agreed to pay. And then they need to, so I went over this with an agent yesterday because he had a buyer that was balking about them putting a percentage on their buyer rep agreement. But you take that buyer, you show them this, and you follow them all the way up to A. The following expenses must be paid at or prior to closing. 1, the seller shall pay. So this A, B, and C fall under A1, which clearly states that the seller shall pay. So you can, if you're in a situation where a buyer is balking about having a percentage put on the buyer rep agreement, you can show them this, and it clearly points out that the seller shall pay the following amount applied to broker fees that the buyer has agreed to pay.
Okay, that makes sense.
So it's now what we'll do if we go down to 2, the buyer shall pay the following expenses. And you see that one line here, it's going to probably cause a lot of issues, especially if you as a buyer agent has agreed to accept less from the seller than what's on your buyer rep agreement, where it says under buyer shall pay the following expenses, which are pretty much the same as what they've always been, but now they've added broker fees that the buyer has agreed to pay. So if through negotiations you agree to accept 2% from the seller as far as your buyer agent compensation, but your buyer rep agreement states that the buyer is going to pay you 3%, title, if they get, and sees that the buyer rep agreement hasn't been amended, still states that you as the buyer agent is going to get 3%, 2% is coming from the seller, they're probably going to look to be charging your buyer an additional 1% for them to pay at their closing.
Why
Okay.
are we sending a buyer's rep agreement to title?
Title might ask for it going forward.
So in that case, would we need to do an amendment with the buyer?
And B, it would be do an amendment with the buyer. Or if your intentions are and your conversations with the buyer is that, okay, the seller is willing to pay 2% commission compensation to me, and you agreed. So now it's all part of the contract. It's not like that's because it was never included in the contract before. So if your agreement overall was, yes, I'm gonna do this, I'm gonna find your home, I'm gonna work for you, Mr. and Mrs. Buyer, but I'm gonna be charging you 3%. Now the seller on the property that they want to purchase is only going to offer 2.5%. That leaves a shortage. Now you had to be working it out, but now it's added to the contract that the brokerage fees that the buyer has agreed to pay.
Okay.
Now it's well within your right to be able to say, okay, per our conversations, I'm going to be working for whatever, I'm going to be striving and finding your home and working within the confines of what the seller is going to be offering to cover my buyer agency agreement with you. So then you would want to make sure that you amend the agreement or do a single showing that brings it down to whatever you're going to be looking to be compensated for. Because if you don't, if that's your intention, but you don't, your buyer could end up being charged that difference at closing.
Okay. So just to be clear, we're going to put hypothetically 3% on the B portion. And then let's say the seller's going to pay $10,000 in concessions. Then that goes on C. So we're going to put $10,000 in C and then 3% on 12A B1.
Yes.
Okay.
And then that clarifies that whatever's put in C is not to include fees the buyer has agreed to pay a broker.
Okay. Thank you.
I don't understand. I'm not getting where we pick up the difference. So let's say that I tell my buyer, I'm working for you. You're gonna pay me 3%. But then the house that they want, the seller says that they're gonna pay me 2%. Where do I put that my buyer is gonna give me that extra, the 1%?
We don't have to anymore. All you have to make sure is
Because I
that,
see,
that all you need to do is make sure title has a copy of your buyer rep agreement that says that they've agreed to pay you 3%. Because now the contract has the verbiage brokerage fees that the buyer has agreed to pay.
that I don't have to amend it to 1%
Well,
before going to
it's
title because now they're,
now, if it's your intention to only accept what the seller is offering you in BAC and not have your buyer client pay the difference or make up the shortage, then you want to make sure you amend your buyer agency agreement down to what the seller is offering.
oh, okay. So the buyer's agent agreement has to equal what I'm going to get in total from seller or buyer.
No. If that's your intention,
Oh,
that
okay.
you're only going to accept what the seller is offering and you don't want your buyers to pay the difference.
Okay, but what if I do want them to pay the difference?
Then you
Where would
you
I
take your,
collect that
you
extra
make sure, you make
1%?
sure title has a copy of your buyer agency agreement that shows what, for the 3%, if we just stick with the 3%. And then
Okay.
then with
Okay.
this provision that's now added, this line that's been added, broker fees that the buyer has agreed to pay, that's now part of this
Mhm.
contract. Title will be looking to add that difference to the buyer's closing costs.
Okay. Okay. Thank you.
Yep. Gene?
So I think one thing to keep in mind is, as we're talking about these changes, is previously, before August 17th, commission on a contract wasn't signed and agreed by any parties. It was at the bottom of a page that nobody signed. So there wasn't any documentation on it. We just kind of all assumed what it was, and we clarified with title company on a one-by-one basis. Then we came out with the 2406 and 2401 and 2402, kind of in a scramble to fix the problem as it was, threatening and looming over us. And so we started using that, and there was a lot of confusion, but we started getting the hang of it. So one thing to keep in mind, because I keep hearing the same question kind of come around about modifying or editing your buyer's rep. Like you said, Alan, never mark it down. And in the previous person said, well, if I want to collect just the 1%, do I take it down to 1%? No, the easiest thing to think is just, you can never collect more than what's on your buyer's rep. It can be whatever number you're agreeing to take, but you can't collect more. And I don't know if you guys are seeing it, but I am having title companies ask me for copies of those. They want to be clear. They want to have that in their file so that there's no confusion on who did they pay and how much did they pay. Did we overpay an agent? But yeah, I just keep that in mind. Never mark it down less than what you want to take. You can mark it up, but don't mark it down unless you're willing to take less.
No, that's exactly right. And but one thing that leadership wants us to do is, going forward, even though we're not required to have an amendment when we lower or lower the amount we're accepting on a buyer's agent, EXP does want you to do an amendment when you lower it. So we have that. And that really comes down to, if it's not so much if, but when any other lawsuits that come down our way, that we as EXP will have a defendable position showing that, one, we tried our best to stay away from broker to broker compensation, and two, that we were working with sellers and buyers as far as following the directive of the lawsuit in DOJ that commissions for both buyers and sellers are truly negotiable. So it falls on a defensible position. Elizabeth.
Hi, Alan.
Hey.
Did you say that after these changes on the 1 to 4, if we check A1B, we don't have to do the addendum regarding broker's fees?
Correct, because that form, the 2406, is, if you go look for it, it's gone.
Great. I'm glad. Thank you.
That was, and I got to commend all of you and all of the EXP agents. That was, you guys took that change. And I think you guys were more prepared than any of the other brokerages that were in the state of Texas as far as being prepared for what started. It came about on August 17th, and kudos to y'all. And now when I saw that they were getting rid of that, I was like, dang, everybody's got it down and now it's gone away. But it's still there, but it's all under 12A1B. So we still have that. Any questions on 12?
I have a question.
Sure.
I've only been with EXP since I've been in real estate. So can you explain? I don't understand the broker to broker and why we're against it.
So, well, broker to broker is pretty much the way it's always been done. And I can only go back to 1992 when I got into this industry. So it's, if you look at our listing agreements, and that falls under, paragraph 5A, and that's where the seller will negotiate with the listing agent on what the total compensation package is going to be for both the seller and the buyer agents. So typically that's where, it's always brought up that that's 6%. So there's no standard. It's just something that's always went along. So the listing agent would put in their listing agreement that the seller will pay 6% commission of the 6% of the total sales price towards commission. And then also under that, then it breaks down to what the listing agent will share with a buyer's agent who brings a willing and able buyer to the transaction. So that's where cooperating comes into place, that the listing agent is willing to cooperate and pay a buyer's agent a certain portion of their overall commission that they're receiving from the buyer to the buyer's agent to cover their fees that they've agreed to with the buyer's agent.
So that's where the broker is working with the broker to pay the buyer's agent. And that's what we're not doing, right? Because
Yes,
the broker, EXP is paying us and their broker is paying them.
correct.
Okay, I understand it. Thank you so much.
Yep. So, yeah, that's where it's cooperating. So we go down here, small change. They got rid of tax on that. They've added an addendum for section 1031 exchange. And this stays the same, just change the dates on this one. So disclosure pursuant to the previous separate agreement, such as so they've gotten rid of any mention of the MLS, other cooperate consideration, and others. So if it is a true broker to broker compensation agreement, then not only would we be doing the 2402, but we would be putting our request or what we are asking for as far as buyer agent compensation in this section here in this paragraph, which says this disclosure is for informational purposes only. So if we're doing it the way EXP wants us to do it, and we're using that paragraph B, that where the seller is paying the buyer agent directly, we put nothing here. This paragraph will only be used if we're having to do broker to broker compensation.
Alan,
yes.
this is Marta. And
Yes.
just to clarify, did you say whenever we're having to use 2402? Is that what you said?
Yes.
Okay,
Yes.
so that is still coming into play, right? Because I still have agents sending that in and trying to explain number or 5 of that form. So are we still doing that broker to broker? That's
No.
confusing.
Not on this listing side. On the listing side, we want anybody submitting an offer to have their request for buyer agent compensation in that 12A1B paragraph. So that's how we want to receive offers, because we're not, as a brokerage, we're not participating in broker to broker compensation. Now, on the buy side, if you're submitting an offer for a buyer and the listing broker says, no, we are not, we are only doing broker to broker compensation, amend your contract, take that percentage or that dollar amount out of that paragraph B under 12 and submit a 2402 compensation agreement between brokers. In that instance, that's the only time that you would be putting something in this paragraph at the bottom of page 10.
Okay, because on the listing side, I still have buyer's agents submitting the 2402 and insisting that their broker is requiring the 2402. So then we're kind of at a back and forth, back and forth, back and forth.
Yes, and if that's ever the case, you can't get past it because we will not accept it as a brokerage. You can have one of the brokers call this other person and say no, this, and explain it, because there is no need for a 2402 when you use that paragraph B under 12, because the seller is agreeing to pay the buyer the amount the buyer has agreed to pay the other broker. They're still getting paid, but it's not being a pass through EXP to the other broker.
Thank you.
I know there's a lot of brokerages out there that still don't get this, and I don't understand why we're still doing it. So,
Hey, Alan, could we take the 2402 and transcribe it into 121 AB and then just send it back for them to sign or initial?
Say that again.
So if they submit it like Marta was just saying, could we take their form, the 2402, just transcribe what they're asking to get paid into 121 AB and then send it back for them to initial?
Yes.
So maybe that stops the back and forth and we just set the 2402 aside at that point.
Yes. So let me jump to, because I'm getting stuff that people want to use this Zoom call. Let me see here. Okay, so a lot of the stuff on this is the third party finance addendum, and I just want to close with this one. I know they're looking to use this room for another class. So the main thing that we want to see when it comes to the third party financing addendum is what they've added to paragraph A. So under paragraph A, if the lender comes out and says that the buyer does not qualify for this loan, now the buyer needs to give the seller not only notice of termination, but also a copy of a written statement from the lender setting forth the reason for the lender's determination. which is huge. No longer can the buyer just say, I didn't qualify, so therefore I'm terminating the contract. Now the seller, the buyer has to deliver to the seller a notice, written notice from the lender stating why they did not qualify. Great for the seller, not so good for the buyer. Because I know there's always times where everybody's looked at the seller going, really? Can we get something from the, everything was great until it wasn't. So any other quick questions? I'll do this again. So just look for more posts. I'll do this a couple more times and try to go through all the other forms and contracts that TREC has modified.
So just to clarify, effective immediately, we will start using the new one before we don't have to wait until January, correct?
That's the only one that's available now on any.
Oh, got it.
So yes, you can use it now. It's a must. If you have it in templates, it has to be used starting the 3rd of January.
And quickly, you said there was a change on the amendment. Was that?
Yes, on the amendment. Very quickly. Yeah, the amendment, the only change on the amendment is they've added paragraph 4, which they modified paragraph 4. So it states back to 12A1B. So if you are having to modify or revise what you put there, you have it on your amendment.
Thank you.
All right. Thanks, guys.